Sometimes a business cannot be saved. The numbers don't add up, the operations cannot be turned around, and the best chance is to wind up the company. This is where liquidation as a formal insolvency option becomes necessary. I am Culverwell, and I help SMEs manage restructuring and create the clarity they need to grow with confidence. In this session, we'll unpack how liquidation works under the Zimbabwean insolvency regime and the COBE Act. We'll also look at the distinction between compulsory liquidation, normally creditor-led, and voluntary liquidation, usually shareholder or director-led. When a company cannot pay its debts when they fall due, or when its liabilities exceed the value of its asset, that company is insolvent. And insolvency makes the company a candidate for liquidation. Liquidation is provided for under the Insolvency Act of Zimbabwe. It is the process of winding up a company, disposing of its assets, and paying out creditors, and if anything remains, shareholders. It is the orderly death of a corporate entity. The most common reason for liquidation is insolvency. The insolvency test is a key measure. Does the company have sufficient assets to discharge its liabilities? Often, when liabilities outweigh assets, the company cannot pay its debts. Failure to pay debts is proven when the company fails to pay, secure, or compromise a debt after receiving a statutory demand, or the company fails to satisfy execution of a court order. But insolvency is not the only trigger. Liquidation may also be ordered where directors are deadlocked and shareholders cannot resolve it. Shareholders fail to elect new directors, fraudulent or illegal conduct by directors or shareholders is uncovered, company assets are wasted or misused, statutory reports are not lodged or meetings not held under the COBE Act, a company fails to commence trading within a year of registration or suspends operations for a year, all shareholders cease to exist, or where 75% of the paid-up share capital has been lost. Even a corporate rescue practitioner may file for liquidation if there is no reasonable prospect of saving the business. In all these circumstances, it is the court that grants a liquidation order. The court considers not only current debts, but also contingent and prospective liabilities. And the principle applied is this: is it just and equitable to liquidate the company? Because liquidation is a last resort, other options, compromise, corporate rescue, or informal restructuring, are preferred if they preserve the business. There are two types of liquidation: compulsory liquidation and voluntary liquidation. Compulsory liquidation is creditor-led. A creditor applies to court. If successful, the court issues a provisional or final liquidation order. Here, creditors must prove the company's inability to pay. This proof is essential because the company may challenge the application. Voluntary liquidation is director or shareholder-led. It applies to both solvent and insolvent companies. A special resolution for dissolution must be passed with at least 75% of voting rights in support. This is provided for under Section 170 of the COBE Act. In all cases, the court still considers whether liquidation is just and equitable. If the court finds that a creditor is abusing the process, acting maliciously or vexatiously, the company may claim damages and compensation. This ensures liquidation is not misused but applied only when it is fair. The consequences of liquidation are significant. For employees, the closure of their employer is devastating, but legally, employee claims are prioritized. They rank second only after the costs of liquidation in distribution of the company's free residue. For secured creditors, their claims are satisfied first from the proceeds of assets they hold as security. For unsecured creditors, their claims come after employee payments. For shareholders, the loss is greatest. They lose the business and dividend prospects. And in most insolvent cases, they receive nothing because liabilities exceed assets. Although liquidation ends a company's existence, it serves an important purpose. It ensures fairness, it protects stakeholder rights, and it resolves obligations in an orderly manner. If your business is facing financial challenges, don't wait until it's too late. Seek professional advice, explore your options, and secure the future of your company.